Good morning, everyone, and welcome to Town Tuesday, this fine November 4th, 2025. Um, hope can everybody hear me okay? No, not there. All right. All right. So today I thought we would talk a little bit about audits. Now, this is a pretty deep topic. It's going to be something that involves quite a lot of detail, and so obviously we're not going to be getting into the really deep stuff here. But just in terms of doing a short overview, so folks are kind of aware of how you can get into these things, sort of what to expect, and maybe some best practices about how to prepare. And then we'll finish out with some of the common pitfalls as published by the Office of the State Auditor of the state of Minnesota. So jumping right on in here, defining our terms, always important. So there are different kinds. A financial audit is an independent examination and verification of the accuracy and completeness of information presented in an organization's financial statements, including a local unit of government like townships. But that is not the only kind. There's also a legal compliance audit. That is something that systematically examines an organization's activities to determine whether or not and meet applicable legal requirements. Now, in practice, these things are often run together, but strictly speaking, they are different. They have different guiding documents. But all right, uh, how can a township get into this situation? Now, these are sort of my categories here. They're not anything that's official, but I tend to characterize the major pathways as voluntary and other than voluntary or required if you want. Now, there are a couple of ways that this request can be made. Probably the easiest or the most straightforward is a resolution by a township board. This is one way that the Office of State Auditor can get involved in a township. Um, so we've got a quotation here from Minnesota statute, so chapter 6, 0.55, the governing body of any political subdivision by appropriate resolution may ask the state auditor to examine books, records, accounts, affairs of their government, and the state auditor shall examine the same upon receiving pursuant to said resolution a written request signed by a majority of the members of the governing body. In that particular case, governing body in this particular case means the town board and not the electors. So if you pass a resolution signed by a majority, you get it to the state auditor. That's one way that this thing can get rolling. It's not the only way, however. One of the odder powers sort of hiding out there in Minnesota statutes, and for those of you who've been sort of following these presentations over time, one of the themes is the ways in which the legislature likes to play hide and seek. Well, this is a pretty nasty one. Um, so Minnesota statute 6.54 provides that the electors at an annual town meeting may petition the state auditor to examine the books, records, accounts, affairs of any political subdivision or any organizational unit, activity, project, enterprise, or fund thereof. So this is well outside of the usual trodden paths for our elective powers. Most of those are found in Chapter 365. Most of those are found in specifically in Minnesota Statute 365.10. But if you are just paging through the law books looking for what the electors can do, most likely you're not going to encounter this one. But it does exist, so it's hiding out there, and potentially, if the electors are mad enough about something, this is a step that they are technically empowered to take. Interestingly, the standards for this are quite a bit lower than the standards for our comparable units of government. This is all it takes is a resolution passed at the annual meeting. There's a form up on the Office of the State Auditor's website. Unlike there's a much more elaborate procedure for cities, but this is something potentially as the town board to be aware of. Um, okay. One major thing to be aware of here is from Minnesota Statute 6.56 Subdivision 1. In these cases, in both of these cases, so if it's a petition from the board itself, or if it's a petition from the voters, it is the township that bears the cost of these things. So upon examination of the books, records, accounts, affairs of any political subdivision as provided by law, such political subdivision shall be liable to the state for the total cost and expenses of such examination, including the salaries paid to the examiners while actually engaging in making such an examination. So in cases where this is actually done, we are theoretically liable for the expenses, including interest if we're late. Political subdivision shall pay interest to the state auditor for undisputed billings when the political subdivision has not paid the billing within 60 days following receipt of the invoice. So that's the same statute, Minnesota 6.56, subdivision 2. But I would say those are the rare cases. We don't hear about those too terribly often at the association. Much more common are the audits that are coming up here. That is the audits that are required by the adoption of optional forms of government, and the audits that are required when you become a certain size. So if you combine the offices of clerk or treasurer, so optional forms of government, this is a thing that you can do. You pass a resolution to present it to the voters at the annual meeting, or they pass a ballot question, actually. So then they adopt this optional form of government, one of which is combining the offices of town clerk and town treasurer. Now, the legislature is aware in broad terms that fewer eyes that are on public funds, the more likely you are to see malfeasance. And so they have sort of reacted to that reality by including an audit requirement if you do this. Now, this can be the right choice for some townships. It's particularly if you're having difficulty filling both posts. You've got a good candidate, but you want to make sure the voters still have their say. This optional form of government is available for you to potentially take care of that. However, it does come with this major drawback. If you do it, you have to have an audit. Now, the frequency of that audit varies considerably depending on how big your township is. So up until this year, the threshold used to be quite a bit lower. It worked out to about $250,000 roughly, but now it's up to about $1 million. So if your annual revenue from all funds combined is more than $1 million, adjusted for inflation, that's 2025 dollars, so $1 million today, then you have to have an audit annually, every year. If the town's annual revenue for all government funds is less than that number, then it is 1 year out of 5. So you have to provide for an audit. It is 1 year out of every 5, but it is the auditor who gets to choose, not the town board. So this is a potentially particularly serious downside to trying to adopt this form of government. Nevertheless, something you should be aware of. If you are having these issues, there are other optional forms of government that are potentially useful. You can consider appointing a clerk from outside of your township. If you go the full appointed route, that's not something you can do if it's just a temporary vacancy type appointment. But we're getting a little bit far afield here. So, okay. The other one is another bit of an ambush statute, or as I like to say it. So this comes from Minnesota Statute 471.697, again, outside of our normal township chapters. And if you've got over 2,500 people and over $1,223,000, then you must have a full audit annually. Now, this is not even if you have separate clerks and treasurers here, you still have to do it. But the good news for most townships is that if you don't meet those thresholds, so if you don't have a combined clerk treasurer and you don't meet the 2,500 and $1,223,000, there's not a specific requirement in Minnesota law to get one of these things. However, you should still be aware in general terms of these things because it's still possible to have one. Of course, if your voters get mad and decide that they want to have your books audited, or if you are concerned about something that a previous board did potentially, you can petition, and so you can be bound to do these things. But that's not the only source There are other ways that these things can be required, including contracts. It's not that unusual in conditional grants and other special statutes, particularly regarding public debt, do require these things from time to time. So just because you don't have to have one because of the structure of your government and your population doesn't necessarily mean that there's another statute. There isn't another statute out there hiding that requires these under certain circumstances. Um, okay, but who is in charge of setting these standards? Well, it's the Office of the State Auditor. Minnesota Statute 6.65 provides that the state auditor shall prescribe minimum procedures and the audit scope for auditing the books, records, accounts, affairs, and political subdivisions in Minnesota. Um, but these standards change depending on your size and depending on your form of government. So that's just something to be aware of. Nevertheless, we're just doing kind of a brief overview here, so we're trying to keep it light and general. Now, most folks think, or at least I think, of a financial audit when I think of audits, but there is this other piece out there, legal compliance audit. Now, there is guidance on this one published by the the Office of the Minnesota State Auditor. And this list of topics comes from that guidance. So at the end of the presentation, I'll give you the website if you want to take a look yourself. But this is what they tell their own folks to look for. So they check on, do you have a proper depository for your funds? Do you have a proper depository for your investments? Are there any conflicts of interest in your contracts? Are you complying with public debt law, public contracting law, complying with proper tax increment financing? And then what they describe as miscellaneous. So in there, the things that they specifically sort of call out in their checklist are open meeting law. There's a fair amount in there, records retention, but it's not just that. It's other stuff too. So this is potentially something to be aware of. But like I say, the full documents are available on the Office of the Statewide Auditor's website, and I give you that website address at the end of the presentation here. Okay. Now, preparation is something that's going to depend on the requirements that your specific township is subject to, which can change depending on the size of the township and also depending on the terms of whatever it is that you however it is that you're getting hooked into this thing in the first place. Nevertheless, we can give some sort of general guidance. So keep that in mind. This is just something that you're always going to want to be. It's a good starting point, but you're going to want to be in communication with folks about the specific one that you are dealing with. So start by making sure you understand the purpose and the scope. If it's limited to legal compliance, you're in one position. If it's including finances, you're in a different position, right? Getting organized. So making sure that you have all the available documentation and organized in a reasonably useful fashion. Remember, we're going to have third parties come in and take a look at this stuff. So they got to be able to have access to it, and they got to be able to figure out where it is. If it's just in a big pile somewhere in somebody's house, you're gonna increase your costs substantially because it's just going to be that much harder for them to actually make their way through this documentation. But some common stuff that you're going to want to make sure that you are gathering and having organized in payroll, bank statements, invoices, receipts, purchase orders, your whatever operational internal controls you have. Make sure that your policies are available. Make sure they're organized. Minutes from board meeting. And then another piece that comes up pretty often in some of the guidance stuff that we're taking a look at is just thinking about the logistics of the operation itself. So where physically is the auditor going to work? You want a separate place for them, something that's comfortable, someplace that has access to the documentation, and all that kind of good stuff. Questions are going to come up. Who is going to be responsible for answering those? Making sure somebody's available means that you're going to be wasting a lot less time. And in this context, time is money. Quite frankly, we hear from townships throughout the state that it can be difficult to find folks to do this work. And one of the ways to stand out and make it easier and cheaper for you to do this is to just be a good client. That is to be prepared for these folks and make sure that you have stuff in the formats that they like to use it so that they can get done with this contract and on to the next one quickly. Okay. So here is just to kind of close out here, we're going to be talking about some of the common pitfalls that the Office of the State Auditor sees. They've got a whole great big library of these things up on their website, but these are some of the ones that caught my eye. So things that you're going to want to be aware of if you feel like this might be coming your way sometime in the future. So common pitfalls that they see at state auditor's office. So failing to document accounting policies and procedures. It's important to have this stuff written down in a not be doing it as just sort of an informal understanding. Multiple signatures, that's something that is required by statute. Our particular statutes are kind of weird about it. They don't say this is required. Instead, they just sort of imply it. Nevertheless, it exists out there. And quite frankly, just from a good governance perspective, even if it didn't exist, you'd probably want to do it anyway. Because the more people who have eyes on this thing, the less opportunity there is for malfeasance. A common one that I would not have thought of is this double or missed payment issue. So every once in a while, particularly with smaller townships, apparently folks won't be careful to mark specific invoices as paid at the time they do it, which can lead to double payment. Somebody sees a bill sitting around, oh God, we got to pay that, not noticing that it already has been paid, or missed payment. I assume the bill took care of that. Whoops. So that's a little best practice that they recommend pretty strongly. And that failure to pay promptly is potentially an issue. So in this state, there's what's called the Prompt Payment Act. And that means that local governments are obligated to pay according to the terms of their contract. So you got to pay when it's due. If you don't, there's an automatic statutory interest and some penalties that can get applied to you. So be careful about that. If the contract doesn't say anything, there is law sort of imposes additional terms on you as a local government. So if you meet at least once a month, that term is going to be 35 days. If you do not meet once a month, that term is going to be 45 days. So for those of you out there who meet only once a quarter, that's something to very much be aware of. You should be having some procedure in place to deal with bills so that they get paid within those Prompt Payment Act timelines. Here's another one. So failing to examine bank statements promptly. Minnesota law imposes an obligation upon bank customers to reasonable due diligence to make sure that the statements sent to them are in fact accurate, and you can potentially lose your claims if you're not promptly challenging a bank statement if it comes back with certain inaccuracies. Now, failing to check invoices, this is kind of a similar thing. If you're one of the more common ways for local governments to lose money dishonestly is monkeying with invoices. So that's the kind of thing that you want to be careful about. High fences make good neighbors, right? So this is one of those things. The way they put it is the most cost-effective way to avoid problems in this area is to create a perception of detection. So that is, if you are examining these things carefully at every meeting, if there's an assumption that somebody's going to get caught if they try this, they're probably not going to try it. So this is a good cost-effective way to potentially avoid some of these more problematic costs. But as I say, so here are some further resources. The Office of the State Auditor's website is very thorough, and it's got some really specific guides, including a long list of common pitfalls. But you've got accounting manuals up there, you've got agreed upon procedures, you've got the full manual for the legal compliance audit. So if you are potentially looking at one of these things, I suggest checking that out, and I suggest taking a good long look at it. All right, I have been seeing some questions in the chat here. Let me stop my share so I can actually go ahead and read these. Just a second. Oh, nice to see you, Pat. Okay. Double checking. Can a township hold their monthly meeting on Tuesday, November 11th? So this is the law is not precise about this, I guess is the correct thing to say. Probably not, is as close as you can come. So what it says is no public business shall be transacted on holidays. This is Minnesota Statute 645.44, quote, except in cases of necessity. They don't tell us what necessity means, and there are a couple of AG opinions saying that the relevant unit of government gets to decide what counts as necessary. So I think it's discouraged. I think you're taking a risk that you probably don't need to. But if you've got a good reason and you feel like you have to, then just be careful to lay out, all right, we think this is necessary. Here's why we think it's necessary at the beginning of your minutes. You are going to be afforded a fair amount of deference. There's case law on this in your determination of necessity. So it's possible that you can do it. I think a lot of folks did it. For example, the year that Juneteenth was added as a holiday, they didn't actually give us a full 30 days uh, to to adapt to that. So I think a lot of folks use that as a case of necessity. There's a fairly old case, I believe 1910s, 1920s era, where the Minnesota Supreme Court just says, in the absence of any showing to the contrary, we're going to assume that there was, in fact, a case of necessity. But, you know, if you don't have to, I would avoid it, I guess, is probably the most precise that we can be here. What happens if the monthly invoice is not received until after the monthly board meeting? It cannot be paid until the next meeting. Does the time start when the invoice is received? Yes, the time starts when the invoice is received. So that's the idea there. The reason they pick 35 is so theoretically you're supposed to be, if you're getting it, the day after, you've got a little bit of wiggle room there. But you do have to be aware of that 35-day deadline in the Prompt Payment Act, because if through some quirk of scheduling, you've got a longer than a 35-day gap, even though you usually meet monthly, you may have to call a special meeting on that. Now, it's not like there's a dragnet out here. I think most of the contractors that we deal with are not super aggressive about getting the interest payments they're technically entitled to under Prompt Payment Act. But if you want to be belt and suspenders about it, I think that's special meeting time. Um, okay, well, any other questions here? Fair enough. Well, thank you very much for your time and your attention, and have a nice morning.